I think it's important to keep in mind two common misconceptions about legislative ethics. The first concerns the so-called revolving door prohibition and whether it applies to legislators and staff alike. So Article 4 of the California Constitution in Section 5E, it says, the legislature shall enact laws that prohibit a member of the legislature whose term of office commences on or after December 3rd, 1990, from lobbying for compensation as governed by the Political Reform Act of 1974 before the legislature for 12 months after leaving office. Note that there is no such limitation in the state constitution or in any state statute that applies this to legislative staff. Also, for those legislators who leave office early, for example, earlier than their term expires, say the middle of their term, the 12 months begins when their term of office normally would have ended. So for example, if they left in, say, March of the year in which their term was going to end, their revolving door limitation would actually be 12 months plus 6 months or 18 months. Also, the revolving door limitation applies to executive branch appointees and their ability to go back and lobby their regulatory agency or the governor's office. They too are bound by a 12-month revolving door limitation. The other common misconception is that only a court of law can remove a legislator from office. If we turn to the California Constitution again in Article 4, Section 5A1 says, each house of the legislature shall judge the qualifications and elections of its members, and by roll call vote entered in the journal, 2/3 of the membership concurring may expel a member. Now, while expulsion has not been used in decades, it is an available power to the legislature, and the courts in California have consistently ruled that it is only the legislative branch of government who shall be the sole determiner of whether or not a member of the Assembly or Senate has been properly and duly elected and whether they will continue to serve. Now, the people did adopt an amendment that allows suspension by 2/3 vote of members. So as you can see, ethics has always played an important role in the legislative process. Legislators, staff, lobbyists, all those working in and around the state capitol should be aware of these and many other rules that are applicable to ethical conduct of legislators, their staff, and others involved in the legislative process in the state of California.